watchers watching from YouTube channel Real Creations. Welcome all of you. Today, let us go through an essay on Lokpal. Let's explain the Constitution, powers, and jurisdiction of Lokpal. The ideal Lokpal is only reduced on paper as decorative piece. It could not be effectively implemented. Let's explain it. The ideal Lokpal is only paper as decorative piece. It could not be effectively implemented. The achievement of the presence of Lokpal in India is very interesting. The current Lokpal Act 2013 has covered a long journey since the year 1958. Lokpal Bill was introduced in Parliament many times, such as 1968, 1971, 1977, 1985, 1996, 1998, and at last 2011. The Lokpal and Lokayukta Bill was last re-established in Lok Sabha on 22 November 2011 by the Government of India, but due to lack of political will, this bill has not been passed for a long time. In passing this bill, there was a tremendous movement of Anna Hazare and Arvind Kejriwal, etc. in the country. The general public openly supported this movement. The pressure on Parliament and the government increased. Eventually, the bill passed by both the houses of Parliament received the assent of the Parliament on the 1 January 2014. It is implemented since 16 January 2014. Thus, now Lokpal and Lokayukt Act 2013 had passed in India. Hope that this act will power to be a milestone in the direction of prevention of corruption. Extension. This act is applied to all India. This also applies to all public servants in India and outside India. Section 1. Constitution of Lokpal. The Lokpal will be a body consisting of a chairman and a maximum of 8 members. 15% of the members will be judicial members. But this and that half of the members of Lokpal will be of the following class: scheduled caste, scheduled tribe, other backward classes, minority and women. Section 3.2. Eligibility. The president of the Lokpal institution will be a person who is or has been the Chief Justice of India, knowledge and experience public administration, Chief Vigilance Authorities, management matter as Chief Justice of High Court. Other person shall be such a person as be dignified and Section 3. Such a well-known eminent person who has a minimum of 25 years of knowledge and experience in any of the following subjects. One is anti-corruption policy, public management. Disqualification. Member of the Lokpal institution will not be a person who member of parliament and state legislature or union territory legislature who have been proved guilty in any matter related to moral turpitude. If any such member, if any such member, if holding any office of trust, if he does any kind of business, profession, or stage management, he will have to separate from it. If some parliament institution will be appointed by the president or the recommendation will be appointed by the president or the recommendation of the selection committee. Selection committee will consist Mr. as a chairman, speaker follows nominated by the president section 4 as a member. Term of office. The term of office of the chairman and members of the local institution shall be for a period of 5 years from the date of his joining or till he attains the age of 70 years, whichever is earlier. But the chairman or members can resign their post by sending a resignation letter to the president. Removal from the post. Section 37 of the Act provides for the removal of the chairman and members from the post and the suspension of them is submitted. Such a petition may be referred by the member into the state presented to the president. The president or member can also be suspended on the or the member shall be removed from office by the president on the grounds when he is adjust bankrupt, when he gets involved in paid employment, when he becomes unfit to continue in office due to physical or mental disability, when he becomes interested under a contract with the government of India or the state government and such interest becomes covered in the definition of misconduct or misconduct. Salary and allowances. One is the salary, allowances and service conditions of the chairman of the Lok Sabha institution will be those which are of the Chief Justice of India. Two is the salaries, allowances and service conditions of the members shall be those which are of the highest judge. Three is no unwarrantable changes in such salary and allowances and service conditions can be made after appointment. E Section 7. Restrictions on employment. The chairman and members of the local institution will be ineligible for reappointment, meaning they cannot be reappointed. On returning, on retiring from the chairman and members, they will not be able to accept any type of employment such as one is any diplomatic duty lord, two is administrator of a territory, three is any post of profit under the government of India or the state government. Four is cannot contest elections in the following institutions for 5 years after resigning: Parliament, State Legislature, Municipality, Panchayat. F Section 8. Secretary and staff. The local institution will have the following offices and other staff members. One is Secretary, category of Secretary to the Government of India. Two is Director of Investigation. Three is Director of Prosecution. Four is other officers and employees. Section 10. Inquiry wing. An investigation will also be constituted to investigate any crime punishable under the Prevention of Corruption Act 1988, which is determined to be done by a public servant headed by Director of Investigation. The investigation wing will conduct preliminary investigation of offences punishable under the Prevention of Corruption Act 1988, G Section 11. Prosecution wing. In order to prosecute public servants in connection with any complaint, an ombudsman will be constituted by issuing a notification by the ombudsman, which will be headed by the Director of Prosecution. After investigation, the case will be arranged according to the findings of the investigation report before the special court by the Director of Prosecution at Section 12. Jurisdiction of Lokpal, Section 14 of the Act is very important. The jurisdiction of Lokpal has been used in this. The following are included in the Lokpal's jurisdiction. One is Prime Minister, past or present. Two is Union Minister, past or present. Three is Member of Parliament, past or present. Four is out of the public servants defined under the Prevention of Corruption Act 1988. Equivalent or higher officers of Group A or Group B. Five is out of public servants defined under the Prevention of Corruption Act 1988. Equivalent or higher officers of Group C or Group D. Next is President, member, officer or employee of following funded or controlled wholly or in part by the central government established or constituted by an act of parliament, the body, board, corporation, authority, company, society, trust, autonomous body, other societies, individuals, association or trust, director, manager, secretary and other officers, any person who is or is holding the following post in society, trust, etc. Receiving donations of more than rupees 10 lakh in a year from a foreign source under Foreign Contribution Regulation Act Rules 2010. Directors, manager, secretary and other officers. Constitution of benches in section 16 to 19 of the Act, provisions has been made of the bench of Lokpal according to the jurisdiction of Lokpal will be exercised by its benches. The benches shall consist of two or more members. Each bench shall have at least one judicial member. Where the bench is constituted by the chairperson, the bench shall be headed by the chairperson. In other cases, the bench will be presided over by a judicial member. The benches will normally hold constituted and reorganized by the speaker from time to time. The work will be distributed by the chairman among the benches. The speaker may transfer a matter from one bench to another bench. The decision of bench will be taken by majority. Process of inquiry and investigation. Provision has been made in section 20 to 24 of the Act for preliminary inquiry and investigation of complaints. According to this, the Lokpal can conduct preliminary inquiry to find out whether prima facie case exists for proceeding in any case, to which the prima facie case appears to be, an order can be ordered to investigate the matter. These on the basis of material, information and documents collected under preliminary investigation. The investigating officer will submit his report in 60 days. D. For is the inquiry report will be considered by the low pass minimum three-member bench and it will be ascertained whether any prima facie case exists. 5 is the above mentioned investigation has to be completed in 90 days. 6 is if the matter is directed for investigation, investigation will have to be completed within a period of 6 months. 7 is after investigation, the prosecution wing or the investigation agency can be approved to file the charge sheet. Next is the competent authority can be directed to take departmental action against the concerned public servant. Next is after the charge sheet is set up, the prosecution wing can be directed to start prosecution before the special court. The website of Lokpal will be displayed to the general public from time to time, in which the pending complaints and complaints dealt with will be displayed. Section 20. The Ombudsman shall have powers to grant sanction to commence prosecution work. Section 30. Powers of Lokpal. The powers of Lokpal have been mentioned in section 25 to 34 of the Act. The Lokpal has been given these powers. One is supervisory powers. Ombudsman shall have powers of superintendence and direction on Delhi Special Police Establishment in respect of such matters which have been referred to Delhi Special Police Establishment for preliminary investigation or inquiry. Section 25. Two is powers of search and seizure. If the Lokpal has reason to believe that any document which in its opinion shall be useful for or relevant to any investigation under this Act are started, secreted in any place, it may authorize any agency, including Delhi Special Police Establishment, to whom the investigation has been given to search for and to seize such documents. Section 26. Powers of Civil Court. Subject to the provisions of this section for the purpose of any preliminary inquiry. The inquiry wing of the Lokpal shall have all the powers of a civil court. Under the Code of Under the Code of Civil Procedure 1908, while trying to suit in respect of the following matters, namely, one is summoning and enforcing the attendance of any person and examining him on a summoning and enforcing attendance of any person and examining him on oath. Two is requiring the discovery and production of any document. Three is receiving evidence or affidavits. Four is requesting any public record or copy thereof from any court or office. Five is issuing commissions for the examination of witnesses or documents. Such other matters as may be prescribed. Section 27. Powers to use services. The Lokpal may, for the purpose of conducting any preliminary inquiry or investigation, utilize the services of any officer or organization or investigation agency, the central government or any state government as the case may be. Section 28. Attachment of property, where the Lokpal or any office authorized by it in this behalf has reason to believe the reason for such belief to be recorded in writing on the basis of material in his possession that any person is in possession of any proceeds of corruption. Such person is accused of having committed an offense relating to corruption, and such proceeds of offense are likely to be concealed, transferred, or dealt with in any manner which may result in frustrating any proceedings relating to confiscating of such proceeds of offense. The Lokpal or the office authorized in this behalf shall immediately after attachment forward a copy of the order along with the material in his possession to the special court in a sealed envelope in the manner as may be prescribed, and such court may extend the order of attachment and keep such material for such period as the court may deem fit. Section 30. Powers. Power to foreclose proceeds, benefits, etc. With a special court on the basis of prima facie evidence has reason to believe or is satisfied that the assets, proceeds, receipts and benefits by whatever name called have arisen or procured by means of corruption by the public servant. It may authorize the confiscation of such assets, proceeds, recipients, and benefits till his acquittal. Section 31. Power to recommend transfer or suspension. Where the Lokpal, while making a preliminary inquiry into allegations of corruption, is prima facie satisfied on the basis of evidence available. One is that the continuance of public servant referred to in clause B or clause E or clause F of subsection I of section 14 in his post while conducting the preliminary inquiry is likely to affect such preliminary inquiry adversely, or To which such public servant is likely to destroy or in any way tamper with evidence or influence witnesses, then the Lokpal may recommend to the central government for transfer or suspension of such public servant from the post held by him till such period as may be specified in the order. Section 32. Power to direct maintenance of documents. Lokpal may, in the discharge of its function under this Act, issue appropriate directions to a public servant entrusted with the preparation or custody of any document or record. One is to protect such document or record from destruction or damage, or B is to prevent the public servant from altering or secreting such document or record, or to prevent the public servant from transferring or alienating any assets allegedly acquired by him through corrupt means. Section 33. Powers of delegation. Lokpal may, by general or special order in writing, and subject to such conditions and limitations as may be specified therein, direct that any administrative or financial power conferred on it may also be exercised or discharged by such of its members or officers or employees as may be specified in the order. Section 34. Continuation. Constitution of Special Courts. Provisions for the Constitution of Special Courts are provided under Section 35. The Prevention of Corruption Act 1988 and the central government may constitute as many special courts as may be recommended by the Lokpal to consider and decide the matters arising under this Act. If trial will be completed in a period of 1 year by the special court, more than 2 years will be extended, that is to complete the trial in 2 years, assessment of loss and recovery thereof. If any public servant is convicted of an offence under the Prevention of Corruption Act 1988 by the special court, notwithstanding and without prejudice to any law for the time being in force, it may make an assessment of loss, if any, caused to the public exchequer on account of the actions or decisions of such public servant not taken in good faith and for which he stands convicted, and may order recovery of such loss, if possible or if possible or preferable, from such public servant so convicted. Section 39. Complaint against officials of Lokpal. One is every complaint of allegation or wrongdoing made against any officer or employee or agency, including in Delhi Special Police Establishment, under or associated with the Lokpal for an offence punishable under the Prevention of Corruption Act 1988 shall be dealt with within accordance with the provisions of this section. To is the Lokpal shall complete the inquiry into the complaint or allegation made within a period of 14 days from the date of its receipt. 3 is while making an inquiry into the employee of the Lokpal or agency engaged or officer of the Lokpal or agency engaged or associated is likely to destroy or in any way tamper with the evidence or influence witnesses, suspend such officer or employee of such agency engaged or associated with the Lokpal of all powers and responsibilities hereto before exercised by it. Section 38. Punishment and penalties. It is provided under Section 46 that whoever makes any false and frivolous or vexatious complaints under this Act shall, on conviction, be punished with imprisonment for a term which may extend to 1 year and with fine which may extend to 1 lakh rupees. No special court shall take cognizance of an offence under subsection 1. One is except on a complaint made by a person against whom the false, frivolous, or vexatious complaint was made or by an officer authorized by the Lokpal. The prosecution in relation to an offence under subsection 1 shall be conducted by the public prosecutor, and all expenses connected with such prosecution shall be borne by the central government. False complaint made by a society or association of persons or trust, where any offence under subsection 1 of the section 46 has been committed by any society or association of persons or trust, whether registered or not, any person who at the time the offence was committed was directly in charge of and was responsible to the society or association of persons or trust for the conduct of the business or affairs or activities of the society or association of persons or trust, as well as such society or association of persons or trust shall be deemed to be guilty of the offence and shall be liable to be proceeded against the punished accordingly, provided that nothing contained in this subsection shall render any such person liable to any punishment provided in this act, if he proves that the offence was committed without his knowledge or that he had exercised all due diligence to prevent the commission of such offence, section 47(1). Notwithstanding anything contained in subsection 1, where an offence under this act has been committed by a society or association or person or trust, whether registered or not, and it is proved that the offence has been committed with the consent or connivance or is attributable to any neglect on the part of any director, manager, secretary, or other officer of such society or association of persons or trust, such director, manager, secretary, or other officer shall also be deemed to be guilty of that offence and shall be liable to be proceeded against and punished accordingly. Section 47(2). Reports of Lokpal. It shall be the duty of the Lokpal to present annually to the President a report on the work done by the Lokpal, and on receipt of such report the President shall cause a copy thereof together with a memorandum explaining in respect of the cases, if any, where the advice of the Lokpal was not accepted, the reason for such non-acceptance to be laid before each House of Parliament, section 48, members, officers and employee of Lokpal to be public servants. The chairperson, members, officers and other employees of the Lokpal shall be deemed, when acting or purporting to act in pursuance of any of the provisions of this Act, to be public servants within the meaning of Section 21 of the Indian Penal Code. Section 52. Protection of action taken in good faith. Under Section 50 and 51 of the Act, the following are provided: protection from litigation, prosecution, and other legal proceedings taken in good faith. Lokpal, employees of Lokpal, employees, agency, public servant. Thus, an attempt has been made to establish a strong mechanism for prevention of corruption under the Lokpal and Lokayukta Act 2013. For the success of Lokpal, it would be expedient to mention the following recommendation of the Administrative Reforms Commission here. According to the Commission, Lokpal should be free and fair. The actions taken by him are personal and formal in nature. His appointment is apolitical. Its status is like the highest judicial officer in the country. His proceedings are separate from judicial interference. Members, ladies and gentlemen, students, scholar, teacher, trainer, professor, professional, officer, official, I thank all respected doctors and directors. I thank all honorable ministers and managers. I thank all honorable advocates, president, I thank all listeners, all my dear friends. I thank the most honorable President Modi. Nice to see all of you. Thank you very much. Good night. Good morning. Thank you.